So hello everyone. So let's welcome everyone for this new video. So we'll talk about the Civil Procedure Code, which came into effect in the year 1908. So we are particularly concentrating on the suits in general in this video. So let's see like what are the topics, list of topics we are going to cover, and list of this probably are the list of sections. So and like first section is like which is section 9 of CPC, courts to try all civil suits unless barred, stay of suit, res judicata, bar to further suit. So when foreign judgment not conclusive, presumption as to foreign judgments. So we'll talk about the every section separately. So let's talk about the courts to try all civil suits unless barred. So courts have jurisdiction when there is a matter of like right to property or a right to hold an office. So because what happens is when a person wants to enjoy the right, the property or hold an office, so there is a right of the like civil procedure code comes into effect. So and also there is another issue whether the office gives a salary or fees, whether the office is tied to a specific place like a temple, religious institution, or any location. But all those are actually comes under the like purview of the civil code because these are legal right. So main issue is a legal right. So what happens in the simple terms when we look at the section 9 of this CPC, a civil court can hear any case, so no like irrespective of any case, so which comes under the purview of the CPC. So when a person has a right to property or a right to hold an office is being disputed. So during that times, what happens is the people will go and challenge, saying that I have every right to enjoy the right to property or a right to hold an office. Uh, and like what happens is like even if resolving that dispute requires a court to examine whether there are issues related to religious practices, customs, rights, or ceremonies. The case is still considered a civil matter. So why this principle exists? Because the main issue is a legal right, and the civil courts have the jurisdiction to decide legal rights. The mere fact that the right is linked to religious does not make it a religious only matter, because so it is a matter of a legal right. So civil courts have every right to decide. And let us discuss about the example. Like suppose if there is a temple and the temple has a priest and two people are fighting for the chief priest position. So in order to decide that, the court may need to understand like what are the temple customs are. So still this is a civil suit because the dispute is about the right to an office. So who actually want will be in a position to hold an office based on his eligibility. So property rights based on religious ceremony. Like person claims property based on a religious adoption ceremony. So during this, like the court must examine whether the ceremony which has happened was valid or not. And but the case remains civil because it concerns property rights. So there is like an explanation which says like even when deciding whether a case is civil nature, so whether like office gives a salary or not, like or the fees, whether the office is tied to a specific place like temple, religious institution, or any location. So it's like what? Why is this important? Because like some positions are like honorary, where the priests are not given a salary. So when it's a religious thing, like a temple priest or a mud trustee, or not linked to a specific building or place. But what happens is like these are still treated as civil rights under Section 9 when there is a right or a title is disputed. So as I told you like earlier, like it's a unpaid temple priest position or like the village head position not tied to any location. So it is all about the section 9. So we will move on to the next thing. so which is like a stay of suit. So this comes under the like section 10, which talks, and like this section 10 is like the uh, which is like no court shall conduct trial between same parties claim under same title. So the court should not encourage anyone from conducting a trial because it's between the same parties and it's under the same title. Because what happens is like when two courts from deciding the same issue, because it is a duplicacy of the, and there is a lot of wastage of time, court's time and also the court officers time. So there is a conflicting judgment. Some may be like maybe supporting the plaintiff, some may be supporting the defendant. So it's a waste of judicial time. So it's like a dispute pending elsewhere because it's like a it it should not waste its time because there are like a lot of pending cases. So and also like there is a directly and substantially an issue. The issue must form the core of the suit because it's an like incidental and collaterally involved, so which was like previously already like filed in the court of law. So because we cannot try the same suit again and again, so court should not encourage from taking it further. And it is specifically for the those like cases wherein like the where have the same parties or people claiming under them. This includes like the same issue, like they should be staying away from that. So because like maybe I'll give you an example, like same issue in two courts, like A files a suit against B in Delhi High Court seeking declaration of ownership over a property. But while the suit is still pending, A files another suit on the same issue in Mumbai court. So this is really a challenging situation because there are two cases between the two parties for the same title. So the Mumbai court must stay the later suit under Section 10 because the suit is already filed in the Delhi court. So it's a waste of time not to try another suit or encourage another suit. And like let me give you another example, same party same issue. So here like a landlord sues tenant for an eviction in court A, but the tenant then files a separate suit in court B asking for the declaration that he cannot be evicted. So it's already there is a case which is pending already in court A, but tenant goes to court B and asking that he cannot be evicted. So give me a decree or an order or a judgment like barring a tenant from getting evicted. So the second suit trial is stayed because both involve the same core issue. Okay, let's move on to the section 11. So it talks about the res judicata. So no, because it's on the same lines. So no court should try the suit directly, which is directly and substantially in issue, litigating under the same title. Matter has already been decided. So here the matter has already been decided by the court, and so we cannot further encourage the person to file another suit. So like I'll give an example. Like a meaning of former suit is like means any suit that was decided before the current suit, even if it was filed later. What matters is the date of the decision. It's because not the date of filing. Example like suit B filed in 2024 was decided before suit A, which was filed in the year 2023. So, like for section 11, suit B is a former suit. Okay. So, that is how we have to decide like whether the suit needs to be encouraged or not because the matter has already been decided. So, we cannot go ahead and like still encourage the suit to be filed. The court should refuse to take it, and like competence of court to check res judicata. There is a like the court has already decided the matter, so we have to see like the court's competence is seen without considering whether an appeal lies. So if there is a chance of like the part any of the parties who's like who has lost the case and like they wanted to appeal, so they have to see like if there is any chance if they can file for an appeal. So in simple terms, if the court had the power to decide the issue, so the fact or that is the decision is appealable or does not affect res judicata. So they have to consider various factors for seeing whether the appeal can be filed or not. So or like it does not affect the like res judicata. So and there is another explanation like because matter must be alleged and denied. So res judicata should be applied. The matter must have been raised, alleged by one party and denied or admitted by other party. So if what happens is like if the both parties never contested the issue, res judicata does not apply because the other party should always deny that there is like a already the case has been decided. So we cannot like you cannot file the case. So that is when like the further suit is like barred from being tried. So explanation 4, constructive res judicata. Like what happens is during these cases, like any matter that might not been have been raised in the former suit is treated as if it was actually raised and decided. So you cannot keep silent in one case and raise the issue later because you have to bring all the issues at a at in the same case when it was first brought to the court notice and was asked to try. So if in the first suit you could have raised defense but did not, but you cannot bring it up at a later suit. That is not right because you have to bring all the issues in the same case when it was tried. So you cannot come later at the later date and come that I didn't raise this issue. So that is the reason why I wanted to file a suit, which is already the matter is already decided by the court. So explanation 5, relief not granted. So what happens is if the plaintiff requested certain reliefs, but the decree did not mention them, it means the court has refused them. Okay, you cannot file a second suit asking for the same relief again. So when the court has already like said that we cannot accept this kind of relief. So when the court has rejected, we cannot go ahead and again like file another suit seeking for the relief. No, we cannot do that. Explanation like regarding the representative suits because it's like if some people litigate like for a public or a common right, all persons like what happens is like persons that right are bound by the result because both the parties are bound by the result, like bound by the judgment which is given by the court. So even if they were not individual parties, this covers public rights and common rights. So res judicata also applies to the execution proceedings. Like there are like suit includes exception proceedings. Like there is an issue includes a question in execution. Form suit includes a prior execution proceeding. So these are the list of things like all res judicata also applies to them. And also like there is a decision by the court of limited jurisdiction. Like it's already been heard and like finally decided by the court that by a court competent to decide that case, this will operate as a res judicata and later suit even if the court could not try the subsequent suit. Yeah, so this is all about the res judicata wherein like the matter has already been decided by the court but it's restricting from filing any further suit between the same parties about the same matter. So we cannot encourage because it's already been decided. So why again unnecessary filing in multiple suits? Because that is leading to nowhere. Okay, and let's move on to another section which is like bar to further suit. Like plaintiff is barred from instituting a further suit because for a particular cause of action, he is not entitled to institute a suit in any court because the civil court procedure is tried in every suit when there is a matter of civil or a legal right and question arrives. So once any court decides like using the civil procedure code, so he cannot go ahead and like file another suit like asking like any other relief or like the matter is already decided. So what happens is like during this case that is like conclusive that because once the court has been decided, so we cannot go ahead and file another suit. Yeah, they are barred from doing it. So section 13 of CPC. So let's like this is where like here like when foreign judgment not conclusive subject to exemptions. Okay, so like what happens is in general, so when there is a like foreign court decisions which are already decided, the matter has been decided by the foreign courts, and that needs to be binded in the courts, like between the same parties or claim litigating under the same title. So uh, that has to be followed or also like executed on the parties which they submitted a proof. So like foreign judgment is because if anyone like wanted to challenge like saying that the the foreign judgment is not correct, so they may be like some of the exceptions which really thinks that foreign courts does not have a competent jurisdiction. So there are the list of exceptions which are like lack of competent jurisdiction. So here in this case, like foreign judgment, like judgment is not conclusive when the foreign court does not have a jurisdiction according to Indian law principles. Because even if it had jurisdiction and its own country laws, so like let's give an example. Like a U.S. court has passed a judgment against a person who never lived in the U.S. and was never served properly. So how could uh, they can give a decision which who is not a legal immigrant or any does never travel to US. So how can the US court can give a judgment on that person? So it purely tells that US court does not have a jurisdiction. And when there is like a not given when the judgment was not given on merits, so during this, like when there is a this happens only when there was no proper evidence and there were no arguments, like not hearing from both the sides, when the judgment was passed based on the ex parte without proper consideration or given without trial. So based on this technicalities, so we can assume that we can make it like it's not given on the merit. The judgment was not passed on merits. So and another one is like incorrect view of international law or refusal to apply Indian law. So what happens is like when a foreign judgment is not conclusive, like it clearly shows an incorrect understanding of international law. So when like they don't have like proper understanding while making a judgment that the law should be tried in a particular way as per the international law. So the foreign and like what happens is like foreign court refuses to apply Indian law. So they don't want to apply an Indian law and wanted to make a judgment based on that. So that is not a right thing to do. Then we can say that it was never tried as per the Indian law. So, and when the judgment was given as per the like not be on the basis of natural justice, so then like Indian court refuses to like will refuses to execute it because, see, based on the natural principles, so of natural justice, principles of natural justice includes there should be a proper notice should be given. There should be an opportunity for both the parties to be heard, and like there should be an like judge who is an impartial. Like they have to be fairly like trying the case. So they like so whenever like make a decisions, there should be pros and cons which needs to be taken, and also the facts and also the evidences which needs to be taken care in consideration. So while giving a decision, so of like and also like when there are some times that are like obtained by the fraud. So those are the things which doesn't needs to be considered. And one more thing, like when we move on to the next section, like which is a presumption as to foreign judgments. So it's like foreign court judgment. It has a competent jurisdiction unless it appears a lack of jurisdiction. So we should not write it off. Like we cannot say that for if it is a decision made by the foreign court, we should not make like we should not tell them that it's not executed in the Indian like Indian land. So because it should be executed in Indian law when it has a competent jurisdiction, when it was tried fairly, so when it was heard by both the parties, so all these things needs to be like considered before like before executing that. So what happens is like when a certified copy of a foreign judgment is produced before an Indian court, the court should believe that it was like a, uh, made a decision which has a competent jurisdiction, and this presumption should be an automatic, prima facie, not final, and it should not be like it's repeatable, can be disproved. So what happens is like here, like however the presumption disappears if the record itself shows lack of jurisdiction. Why this rule exists? To make international litigation easier, so avoiding necessary proof of foreign court authority, ensuring speedy recognition of foreign judgments. So this actually like it's a provision that like whenever a foreign court makes a judgment that needs to be executed in the Indian land. So because like we have to we have to obey the law of the other land where the incident happened, because based on this fairness, like all the things have been taken care of. So yeah, so this is all about the uh, section 14. So yeah, so yeah, please do subscribe and like press the bell button. Thank you.